What was the business, sir?
The business was, I'd always been a collector of movie memorabilia, TV memorabilia, autographs, that sort of thing. And basically I thought I could do that myself, but include the costuming as a sideline, so people can come to the shop, buy stuff, but also hire.
Start a shop?
Yeah.
Had you ever owned your own shop?
No.
Consequently, what you did with your business plan is that you went to somebody to invest. Now, what were the circumstances in which you lent him money in December 2014, madam?
Well, he sold it to me, Judge. He came and showed me the photographs and, oh, this is going to be amazing, Mum, this is going... And, yes, he sold it to me, Judge.
He did?
And I thought, this is what he needs to get him out of bed in the morning.
What did it do to you when you saw him down, trying his best, and it not working out for him? What does that do to you as a mum? It's OK. You love Mum?
Of course I do. She's my rock.
Business isn't going well, but before we get there, I'm afraid, sorry, I've got to go and ask what you lent. Got to go back to the beginning. How much did you lend Wayne?
I lent him £2,000, Judge.
That was £1,600 for rent and £400 for stock.
Correct.
That was in December 2014, and the business opened in February 2 months later.
It did.
Now, at the time you lent him that money, you prepared a note. Not exactly the type of note that one would write from a bank, but is that the note?
Yes.
I, Wayne, owe my fabulous, lovely, gorgeous, spelt wrong.
Yes, I realise
That describes you as gorgeous. Lovely, gorgeous, helpful, all-time, one and only best mummy in the world, whole wide world, £2,000, dated the 18th of December 2014. Now, I have to speak to you, Mum. I approve, and it's terribly important that this is in writing. It's important because if it wasn't in writing, your case would be over in seconds. You wouldn't have an enforceable contract. That doesn't get you out of the woods in law. The major problem with that document is it doesn't set out the repayments or when the money is due back. Now, in early 2016, he's paid you nothing for the £2,000. In early 2016, you need to go to and fro, presumably to deliver some of this stuff to people, right? Mm-hmm. So you need what?
Transport.
A car. He came to you, the car had broken down. How much money did you lend him?
£3,500, Judge.
£3,500. Again, at this stage, he signed another agreement. We're now up to £5,500, correct? Let's have a look at the agreement he signed. Now, what it says at the top is car, £3,500, right? You understood that that was the money that you were borrowing. Yes. And then, madam, what I've got are various instances, exactly as you described, as you would have done if you'd been paid anything back for the £2,000, £20 here, £30 there, etc. Madam, even those sums that you've set out there don't add up. What happened on the 27th of April 2016? It's another aspect of your claim. He's hardly paid anything back, roughly 765, not entirely sure of the dates because there's no record of it. But on the 27th of April, you end up paying a bill in respect of his shop. You don't appear in your application to be applying for this £490, madam. Would you like to amend your application and make an application today?
Yes, Judge.
Excellent. Splendid idea. Now, that's one speeding fine. A second?
Yes.
Were you not notified for this one?
Yes. And I appealed against this one. But again, they wouldn't let it lie.
Wouldn't let it lie? You were speeding. They don't sit there, you understand, going through the court documents, somehow with some offence to you, sitting there with a cigarette going, oh, if I could let that one lie. Oh, it was only 50 miles an hour. Poor man. His mum loves him. Let's let it lie. She paid a speeding fine, £370. Would you like to amend your application in respect of the rest of your debt for £370, madam?
Yes, Judge.
What a good idea. In order for you to persuade me that I can do anything about this situation, you have to be able to say to the court, this is an enforceable debt. The difficulty that you have, although you've got something in writing, what the court has to ask itself is whether or not there's an intention to create legal relations. In other words, whether this is a debt the court can ever enforce. It is acknowledged that he's taken this money from you. I'm sure of it. But the problem is, at the time that you extended him these two lines of credit, the £3,500 and the £2,000, you effectively told him to pay you back when he could. Because there isn't any finite time for when the debt is to be enforced, it seems to me that this is not an enforceable contract in law. However, during the course of the proceedings, it has emerged that your son negligently acquired 2 speeding fines. It seems to me I have no difficulty finding those were his responsibility and not yours, and that you never would have paid those sums unless it was quite clear that that money was coming back to you. This court awards you the £490 for the first fine and the £370 for the second. I dismiss your original application, but give you a full award for the fines that he accrued. The award of this court, consequently, is £860. That's the award of this court. Click here for more exclusive YouTube videos. And don't be a moron. Subscribe and keep up to date with all the best courtroom action. Jazz hands, Michelle.